Hi, I'm Paul Mallis, partner in the law firm of Young, Marr, Mallis and Associates. Welcome to the Paul Squared podcast. I started my career in the district attorney's office, and in 2016, I turned my focus to exclusively defending clients charged with crimes. I created this podcast to provide an overview of the criminal law process and to answer the questions I most often get when I first meet prospective clients. My goal is to protect my clients' rights and to guide them through the stressful process of being charged with a crime. While this podcast serves to provide general guidelines around the practice areas we discuss, you should always consult directly with an attorney to make sure the specifics of your particular situation match up with the applicable laws. The decision of choosing an attorney is an important one, and you should give it careful thought before deciding. If you need representation or just have questions, please don't hesitate to contact me at 215-639-5297, or you can visit our law firm's website at www.ykacrim.com. That's ykacrim.com.
We're back with Paul Mallis, and we're going to finish up our introduction to the criminal process. So welcome back, Paul.
Thanks for having me back. Happy to be here.
Absolutely. So we talked about the basic steps that happen whenever somebody is facing criminal charges. So an arrest or a detainment that could later lead to charges, or a summons in the mail. There's three sort of kickoff things that typically lead to somebody realizing, oh, I have criminal charges I'm going to have to defend myself against. That's sort of the starting point. And then after one of those three things happens, you have an arraignment hearing, a bail hearing, and preliminary hearing, which we discussed in detail. And that's sort of the intermediary stages, determining, A, does somebody need to be in jail? If they need to be in jail, do they have to put money up, or can they be released on their own recognizance? A preliminary hearing, is there enough evidence to move this forward, and giving you sort of sneak peek at the prosecutor's case. Then after that, if the case continues to move forward, you have status conference hearings, which are basically going to be the stages where you typically see plea deals start to be worked out, or negotiations on things like that, leading up to a trial. You can have hearings throughout that, suppression hearings on evidence and different things like that to preclude it. But it's all sort of leading up to a trial where you can either be in front of a judge or jury. And I forgot to ask you this in episode 1. How's it determined whether you're in front of a judge or a jury?
It's a good question. In part, it's determined by what you're charged with. If the crime is punishable by at most 6 months of time, then you're only entitled to a judge trial. We call it a waiver trial or a bench trial by law. So if it's a crime punishable by more than 6 months, then you'd be eligible for a jury trial. So that's an important that's what the rule of law is.
So is it, when you're eligible, does that mean you're automatically entitled to it, or who makes that decision? How does that work?
Yeah, you're not entitled to it. You would have to elect. It's called a jury demand. You'd have to demand a jury trial. But the prosecutor could also demand a jury trial if the client wishes to have the trial by bench. I have seen very rare occasions where the prosecutor elects to have a jury trial. So I think the starting point is, do you qualify by law for a jury trial? If so, do you want a jury trial? That question depends on the facts of the case, really. If it's cases involving children, sex crimes, you might not want to steer the case toward a jury. If it's a case that's driven by the law, like there's serious legal issues in the case, then you want that trial to be heard by a judge. But if it's a question of fact, where the case is factually driven, that's probably a case that you want to steer toward a jury.
And so you have this trial, whether it's judge or jury, and the decision of which one goes into what you just described. You have a guilty, not guilty plea or verdict. If there's a guilty verdict, there's a sentencing stage where a judge based upon guidelines that are calculated, are given guidelines, but they have a lot of discretion into how to apply guidelines or not in the sentencing phase. And after all of that, the defendant preserves the right to appeal all or some or pieces of that whole process I just described, to get things reversed, to get a new trial, to ask for things to be reduced, other things like that. So is that an accurate, basic depiction of the steps in the criminal process?
Absolutely. Very
Okay.
accurate.
So I think we went into a lot of detail on this. So on this episode, we want to get into some sort of commonly asked questions and the things that people sort of the nitty gritty of, all right, all those, the things that sort of happen in those stages, what should or shouldn't people be doing, what the different things mean and stuff like that. So that's what episode 9 is going to focus on. And so my first sort of basic question to you, are there any general guidelines, advice you give to people who are facing arrest or booking or something like that? So say somebody gets a summons or they're going to get charges or whatever, and they're worried about this, and they come to you and they say, I want to hire you to represent me. And what am I supposed to do? They're going to come and arrest me. They want me to turn myself in. What's some basic thought process or guidance do you give somebody in that situation?
Well, if somebody knows that they have an arrest warrant that's out for them and they know that they need to turn themselves in, I mean, at that point it's just about doing a voluntary surrender, and talking to them, explaining to that client what the steps are going to be. If it's a case where the case is in the investigative stages and there is no arrest warrant, that's really where you want to be very careful, because a lawyer will help kind of steer the ship in the direction that you want it to go, that's going to be favorable for the client. So whether we give a statement or we don't give a statement, or if we do give a statement, what statements do we want to make? When a client comes to me and it's in the case is in the investigative stages, that's great, because I can steer the direction in which the case goes, versus an arrest warrant's been issued. There's not really much I could do at that point other than we do a voluntary surrender and I explain the process.
And I would guess throughout all this, if statements are made or people have already said things or given information to the officer, you're not unringing that bell. It's out there now, and you're going to have to deal with it. So getting ahead of those things, and sometimes silence, I would guess, is the best answer. Don't say anything.
Right.
Is that generally advice you would give people? Is like, listen, don't volunteer information unnecessarily.
Yeah, 100%. You can be polite and you have to be polite and respectful, but you can be polite and respectful by invoking your right to remain silent. You don't want to give any statements, because those statements are going to be used against you. Even though you think that those statements are going to help you, they'll be used against you in some way, shape, or form in the case. And like you said, Pete, once you make the statement, that's it. You can't unring a bell. You could challenge the validity of that statement, which I'm sure we'll get into a little bit more. But you want to invoke your right to remain silent. You do not want to speak without counsel present.
And so when you say your right to remain silent, I think that sort of jumps into the next questions I had for you. So like, what are people's rights following arrest? And I think everybody's heard of Miranda's rights, but can you describe those, and what does it mean, and what's the practicality of those words we've all heard on television?
Yeah, right. Miranda rights, I get this all the time from clients. They didn't read me my rights. How the case should be over. Common misconception. Miranda, in layman's terms, only comes into play when you're in custody, you're not free to leave, and the police are asking you questions designed to elicit an incriminating response. Did you do the crime? Did you commit the crime? Did you do the crime? You're not free to leave. In those types of situations, what we call custodial interrogations, police need to read you your Miranda rights. You have the right to remain silent. Anything you say can be used against you. You have a right to an attorney. If those rights are not read to you and you're in a custodial type interrogation, then any statements you make can be suppressed. They can be ruled inadmissible at trial. Your attorney could challenge the validity of the statement that you gave. Now, if you are read your Miranda rights in a custodial type interrogation, and you still elect to speak, to give a statement, you could still, in limited circumstances, challenge the statement that you made. Even though it was not a custodial type interrogation, we could challenge the statement that was made in a non-custodial type interrogation and challenge the voluntariness of the statement. For example, I have a young lady who's charged with involuntary manslaughter and drug delivery, and she was brought into the police department for questioning. She was not free to leave. She was at the police station, and they were asking her questions. Who did you deliver the drug to? What type of drug was it? Statements that would be incriminating. And she was read her Miranda rights, and she did sign what's called a Miranda waiver rights form, which acknowledged that she was giving a statement freely and voluntarily. I, in that case, am still challenging the validity of her statement on the basis that her statement was not given voluntarily. We're framing the issue in the context of, had she not given the statement, she would have been arrested. So if that was the case, then the statement was not voluntary, despite the fact that she was read her Miranda warnings. And if the statement was not voluntarily given, then she did not voluntarily waive her right to speak at that time. So you could challenge statements that are given with or without Miranda.
But it sounds like one way or the other. Once you've made statements, whether you've been read your Miranda rights, not read your Miranda rights, or otherwise, you're now facing an uphill battle to unring that bell, using that phrase again, where if you just invoke your right to remain silent, which you have a right to do, and say, I want to get an attorney involved and do it through a more systematic process, whether it's through a statement or and I'm guessing some type of interview where you would be present or something like that, that you have control over what's said or not said. And I would think that your best bet is invoke your right to remain silent.
Absolutely, 100%. For me to, it's easiest for me to draw upon examples of cases to illustrate the point. Another case, a rape case, sex offense case. During the investigation, this is prior to the inception of my representation, police went to speak with my client. The whole defense in the case is that the sexual encounter was consensual, that the complaining witness victim gave consent. During the investigative stages, police went to speak with my client, and he said he never had sex with her. Well, if the whole defense is that they had sex and it was consensual, now the statement that he made is going to be used against him.
Right.
So it's just an example how the statement that you make, it's an uphill battle from there.
And I think that I would guess that people who talk to the police early on are probably thinking in their minds, well, if I just say the right things, I'm not going to be charged here. I'm going to somehow get out of it. But all they're doing is, look, if you're in the police sight at that point, I would think the chances are it's going to progress. Are you just giving them more ammunition or not to support their case?
Right, exactly. Police are going to be friendly, tell you that it's okay. We just want to get the information. No, they have a job to do, and that job is to uphold the law, and they're going to do anything they can and manipulate the situation in any way they can to try to achieve their goal, which is to uphold the law.
So that leads to my next question. Is a police officer allowed to lie to someone they're questioning?
No, obviously not. I mean, as law enforcement, they're held to a higher standard than, somebody that's not in law enforcement, and they cannot be deceptive with their line of questioning. There's a whole body of law on that issue, and they need to explain to you the reasoning for their questioning, the subject matter of the investigation. Um, they certainly cannot be deceptive in any way, shape, or form.
But I'm guessing that question or description of deceptive is, again, could be in the gray area on what you consider deceptive, they may not. And, where they're trying to advance an investigation, they might be clouding the question a little bit, or
Sure.
inferencing something that may not be the accurate.
I have another client right now who is charged with the unlawful transfer of firearms. She had uh, sold firearms in exchange for drugs. Big no-no in Pennsylvania. You can't transfer firearms like that. And the way that the police discovered these firearms was while they were investigating the drug dealer, completely unrelated case. So they go to speak with my client, who's kind of led to believe that they're investigating the drug dealer, not this unlawful transfer of firearms to the drug dealer. And so
Right.
they get a statement out of my client about the transfer of the firearms. So they were very kind of gray with the subject matter, why they were questioning her. But you're right. I mean, there's no black and white. You know, this is what they don't need to be technical about their line of questioning.
Right.
So there is a gray area.
And again, it doesn't matter what their question is if you don't say anything, if you don't answer it,
Exactly.
which
If you
you have
just
a right to
right,
remain silent,
right. On the
because
advice of
anything you
counsel,
say will be used against you.
right, right. On the advice of counsel, I choose to remain silent.
Yeah.
Done.
Yep. So, sort of tangentially to that, so you have police officers that are questioning people as part of their investigation. What about searches? I'm sure this comes up all the time, that you have somebody who's arrested, pulled over, whatever it might be, that should someone agree to let the police search them, their car, their home? Like, what goes into the considerations of acquiescing to a search request?
Well, look, I mean, certainly if you've got nothing to hide and it's a kind of an innocent, the police want to search your car, you've got nothing to hide, that's one situation. But the police aren't asking to search your car in a situation where you've got nothing to hide. They believe that a search of whatever the object is they're trying to search, be it your home or your vehicle, they believe that a search is going to reveal evidence of a crime, and they're pretty good at what they do. So you never want to consent to a search, ever, ever, ever. Police could make all the promises in the world. Allow me to search, you'll go home that night. Well, the next month later, you're going to get an arrest warrant or you'll be charged. So you never want to give consent. There's a couple ways though that police could search. One way obviously is with consent, but they can also search by getting a search warrant, by getting a judge to approve a warrant to search the location that they want to search, your vehicle, your place of employment, your residence. And in that search warrant, they need to state probable cause. They need to give probable cause why they want to search it. So that's another way. Consent, a search warrant. They can also search if they have probable cause and what we call exigent circumstances. They have probable cause to believe that a search of the object that they want to search will reveal evidence of a crime, and it's immediately necessary that they search this area. Gun in the car, somebody's life's being threatened, they need to get in there. So those are some ways that police can search even without consent.
Well, improbable cause is a legal term. I'm sure most people out there have heard it before, but describing it, is it accurate to call it saying, look, they have to have a justified reason for even inquiring or looking or searching or asking or whatever it is that they're doing? Like, if they don't have that, if it's a hunch, or they just saw someone walking by and said, hey, can I search you, and had no reason, that probable cause is the standard that says you have to show me, the court, a reason why you would have done the action that you did. Is that an accurate description of that?
Yeah, yeah. And the best example I can give is, you're in the car. There's a car stop for whatever the reason may be, speeding, red light violation, and police. You roll down the windows and they see a cloud of smoke, and police smell marijuana. Well, isn't it reasonable to assume that if they search the vehicle, there's going to be marijuana inside the vehicle? That's probable cause. Okay.
Right.
Or police are down in, Kensington and Allegheny, which are high drug crime areas in Philadelphia, and they see, hand to hand transactions going on. outside of a home, on a front doorstep of a home. Okay. Or police see a guy on the corner with a bulge on his waist that resembles a gun. That's probable cause. So there's no real, the definition, I think the legal definition that they teach you in law school is specific and articulable facts that they need to use to justify. But those are examples of what we mean by probable cause.
Gotcha. And I think you answered this question, but I'll just ask it again. We see on TV all the time that after an arrest in particular, that you shouldn't say anything and demand to see your lawyer. And it sounds like you agree with that, because at that point forward, especially after arrest, they already think they have probable cause to bring arrest charges against you. And now they're just gathering up more facts to support that. Anything you say is just going to be added into the file, regardless of if you think it's going to exonerate you or not.
Yeah, exactly. You don't, at that point, the arrest has been made, the decision to charge you has been made. There's no going back on it. It's just illogical to give any sort of forget about, lawyer. Now, why would you ever give a statement in that type of a situation? It's more so when you're in the investigative stages, you might want to give a statement to help steer the direction in a more positive way for your case, but you want to do it under the advice of counsel.
Right. And so and again, I think it's a good piece of advice that be polite, don't be combative, don't, be giving them a reason to hate you to decide to go after you harder than they need to. But, giving the words of, hey, I'm choosing to remain silent under the advice of my attorney or my counsel or something
Right.
like that is the right approach to tell them, no, you understand your rights. You understand that they understand at that point that you're seeking or will have counsel that is going to represent you, and that sort of sets a different bar for them as well, right? Once they inform them that you want counsel or you want a lawyer, does that change the tone of what they can or can't be asking you at that point?
Yeah, once you invoke your right to counsel, that's it. The line of questioning stops. If it doesn't, that's a problem. The statement could be subject to suppression. Once you clearly and unequivocally invoke your right to counsel, the line of questioning must stop. That's what the law demands.
So that's an interesting, I guess, point or question to make. So let's say someone's arrested, or they're not arrested. They're being questioned by the police, right? And they say, "I invoke my right to be silent." Does that mean that the police have to stop asking questions then, under
Yeah,
a right to remain silent as well?
absolutely.
Okay.
Absolutely.
Okay. So
Yeah.
either one of those saying, I want a lawyer, or I'm invoking my right to remain silent, the police, that should be the trigger for them to say they're not allowed to ask any more questions.
Right. Police questioning must stop at that point in time.
Gotcha. So if someone invokes the right to have an attorney, what if they can't afford to hire one themselves, or they're worried about that? Can they represent themselves? What are someone's options for, let's say somebody can't afford you. They would want to hire you, but they can't afford to hire you. What are their options?
Everyone's entitled to counsel. Everyone is entitled to counsel, whether or not they can afford counsel, to hire us or to hire counsel or not. Um, Whether or not you qualify for the public defender is a matter of whether or not you're deemed indigent. But let's just talk about, like, let's say the police are in the investigative stages. No decision on an arrest has been reached yet, but police want to question you, and you're destitute. You don't have money for an attorney. You're still entitled to counsel. If you invoke your right to remain silent and your right to counsel, then you could speak with counsel. And if you can't afford counsel, you can contact public defender's office. There are ways to do that. So just because you can't afford a lawyer doesn't mean that you somehow have waived your right to counsel at that point. That's not how that works.
But there is some calculation as to whether you can't be sitting with $100,000 in the bank and say, I want a public defender.
Sure, there is a calculation. They look at your financials and whether or not you meet the standard as an indigent person, and then you qualify. But let's say, but we get a lot. not we, but we see a lot in this business, a client who does not meet the standard for as an indigent person, but they cannot afford to retain a private attorney. So what happens with that client? Well, they could go to their court appointed referral lists where the lawyers on that list have agreed to take cases at a much lowered or reduced cost. The client could certainly avail uh, themselves of that list, the lawyers on the list. They could also choose to represent themselves and represent themselves, what we call pro se. So there's various different ways. Just because you can't afford the full cost of a lawyer doesn't mean that you've waived your right to an attorney.
And I'm sure you get this question sometimes that someone says, all right, I've hired you, Paul, and and you get a case dismissed or the charges are dropped or one of those things. Is there any practical recourse for them to get the government to pay for the money they spent defending themselves?
Your question is, can they get the money back
Yeah.
that they've hired for an attorney? Like, if somebody hired me, I got the case dismissed, can they go after the government to get legal fees back?
Yes.
The answer would be no.
Right.
That would be great. But the answer would be no for that.
Well, I know oftentimes in civil cases, and there's different jurisdictions that have different rules where if you lose, that doesn't mean the other side has to pay for your expenses. And just wanted to clarify, it's the same thing here in a criminal defense case. Like, you have to make your own educated choices about defending yourself. Do you want to choose your own attorney? If you don't have the money and you're considered indigent, and an attorney can be assigned to you through the public defender's office, or you can go to one of these, counsel systems that will allow you to have a much smaller pool of attorneys that you could probably choose from for a cheaper rate, or represent yourself in court. That's essentially your options, in terms of choosing those. And each of those have their pluses and minuses. Certainly, I think in a perfect world, everybody would want to be able to choose their own attorney who they thought would best represent them, but monetarily, sometimes that fits or doesn't fit.
Right.
But I think it's also important to just make people aware that even on simple cases, I think there are dangers in representing yourself. You have to be cautious of, just because of the things we described before, which are the system uses its own language. It's very rules oriented, where a simple small thing that isn't done the right way, or done in the right time, or done with the right proper language, can make a case, continue that otherwise wouldn't. So you have to be cautious of those things, and someone determined they're going to represent themselves.
Absolutely, for sure. Well, just one other thing I'll just
Yes.
say, because
Mhm.
if a client does choose to represent themselves, they're still held to the same standard that an attorney's held to. So they need to be aware of the rules. They need to be aware of the law. So I would never advocate for a client to represent themselves, but they do have that ability. And if they choose to exercise it, they're held to the same standard that a lawyer is.
Right. And somebody who they're held to the same standard you are, who's gone through 3 years of law school, who has
Right,
practiced for many, many years and done thousands plus cases, like
right.
they're gonna be the judge is gonna look at them and say, I expect you to conduct yourself the same way that Paul Mallis would.
Right.
And that's a tough standard.
It is.
Yeah. So I think we already talked about when someone's not under arrest, but the police want to talk to them. So my next question is there a deadline for certain criminal charges to be filed following, I guess, well, let's talk about that first. Let's say somebody's had something that happened in the past. They're worried that it could result in charges, but they haven't, maybe even the police investigated it. Can we talk about, is there a time limit that on certain cases, or just broadly in general, however you want to describe it, that say, hey, if this much time has passed, you don't have to worry about something that's happened in the past? And then additionally, is there anything that happens sort of post that stage? I guess once someone's arrested, charges have been filed, right? So is there a possibility that someone could have gotten a summons or some other kind of legal proceeding where it's not a full arrest, but they should know a certain amount of time has passed where they're like, look, this isn't going anywhere. Could you talk about that, a little bit?
Sure. So I think the starting point is yes, in some situations there's a time limit, and those situations are where there's an arrest made without an arrest warrant. What do I mean by that? Really, we're talking about DUI type cases where somebody's pulled over, they're stopped, they're given field sobriety tests, they're given a blood test, they're arrested for DUI. In those types of situations, the rule requires that charges are filed 5 days from the date of the arrest. And if it's not, which oftentimes it's not, and I'll talk about that some more, then the client can file a motion to dismiss for violation of that rule. But the client then bears the burden to show that the delay in filing somehow prejudiced his or her case. So, for example, you're arrested for a DUI today, 9 months later, charges are filed. Clear violation of the 5-day rule. Now you have to raise the prejudice issue. How did the delay in time between the arrest and the filing date prejudice your case? And that's not always easy, but that would be the standard to show in order to get a case dismissed for violating that 5-day rule.
Gotcha.
So that's only for arrests that are made without an arrest warrant. There's obviously other matters where there is an arrest warrant that's made, and there's really no clear definitive answer I can give you. There's really, other than there's no time limit. There are statute of limitations that apply in certain situations, but barring those statute of limitations, if the police are investigating a matter, the investigation could take a year, 18 months, 24 months before charges are filed. Look, I'm dealing with a rape case right now. A client was, the allegation came about early on, 2024, maybe like the second or third week of January, and charges were only just filed October of 2024. So, while that client may have thought that he or she was, in the clear, they weren't. And it just depends on the nature of the investigation, how long that takes.
And I would assume the seriousness of the crime. If the Zodiac killer, who they haven't caught, they suddenly found out who he or she was tomorrow, they could arrest them for the murders that happened 40 years ago, 50 years
Yeah,
ago.
right. That happens. We call them cold cases. That
Right.
happens a lot.
Right.
Yeah.
So I would assume that there is no set rule for, hey, if X or Y or Z amount of time has passed, you're in the clear. It's going to be based on a whole bunch of factors, and whether there's a statute of limitations that's legally says you can only charge someone for this crime, within a certain period of time, or some actions happen like you described where there's a arrest warrant, but they missed a deadline and you have to meet these pieces. So the point being on all that is you can't just count that something that happened in the past is going to be gone because enough time has passed.
Exactly. Right. You can't discount that.
Okay.
Yeah.
And sort of tangentially to that question is that, more serious crime are going to have no statute of limitations. A murder can be prosecuted at any point in time. So can we talk about the different levels of criminal offenses? So I think, and correct me if I'm wrong, there's 3 basic criminal levels, and they have all different gradings to them, but you have summary offenses, misdemeanors,
Right.
and felonies. Is that correct in
Right.
Pennsylvania? Okay.
Yes.
Can you talk about what each one of those is and give an example of what crime is that fits in that?
Sure. Summary offenses could be public drunkenness. They could be criminal mischief. We can talk about a summary level type harassment, disorderly conduct, ordinance type violations, you know, misdemeanor cases, assault, simple assault, um, bad checks, DUI type matters, to the more violent type felony cases, aggravated assault, rape, robbery, obviously, murder type cases. The difference, the legal difference is your exposure. Your the punishment that could be imposed, and your exposure is based on the grading of the crime. For instance, if it's a summary type case, your maximum exposure is 90 days. If it's a misdemeanor type case and it's a misdemeanor of the first degree, which is the highest type misdemeanor, your exposure is 60 months or 5 years. So the difference really in grading is that your exposure changes. So it's not so much just that, it's not only just the nature of the crime, it's what your criminal exposure is.
And the two sort of go hand in hand. The more serious the crime, the bigger your exposure is. It's probably, unless there's extenuating circumstances, the chance that you're going to go to jail for a summary offense is probably much, much lower, than you would for a misdemeanor or a felony.
Although I did have a jury trial years ago where we got a not guilty on a robbery, and in juries, the judge adjudicates guilt or innocence on the summaries, not the jury. So we get not guilties across the board on all these robbery charges, and then the judge not only finds him guilty of the summary offenses, but imposes jail time on the summary offenses to make a point.
Right.
So that's the one time in all these years I've seen jail on a summary case.
Which I would think, again, extenuating circumstances, that a drunk guy who's stumbling around outside in public drunkenness, chances
They're
of
not
he's going to jail, right?
in jail.
Pretty
Yeah.
low anyway.
Right.
And within each one of those, summary, misdemeanor, and felony, I think you touched on it, there's different grades. So
Right.
it's not like every misdemeanor is eligible for 5 years in jail. You have grades
Right.
1, 2, and 3.
Right.
And then even
Yeah,
subparts to those.
Right. So we have misdemeanor of the first degree, misdemeanor of the second degree, misdemeanor of the third degree. Misdemeanor of the first degrees, your most exposure, 60 months. Misdemeanor of the second degree is 2 years of exposure, and misdemeanor of the third degree is 1 year of exposure. So it just depends. With felonies, we have felony ones, twos, and threes, so your exposure changes in that regard as well. So it just depends on which are you charged with, a felony, misdemeanor, and then which degree are you charged with, and depending on which degree you're charged with, that'll dictate what your exposure actually is.
Got it. And we had talked a bit on episode 8 about bail and bond, but I had a couple follow-up questions about that. So,
Sure.
If I'm correct, the decision of bail is made at the bail bond hearing in front of the judge, and they're determining basically, hey, either A, you should not be let out of jail. Such a serious crime, you're a flight risk or one of the danger to society. One of those things where they say you need to stay in jail. Just because it's timely for when we're recording this podcast. P. Diddy has been
Right.
no bail or bond because he's got too much money, too much ability to flight risk. He's all the things that he's been alleged to have done are serious enough. They're saying you're remaining in jail. So that's somebody who doesn't matter how much money he would put up, they're keeping him in jail at this point.
Right.
But then you have the other category of people where they say, all right, we could keep you in jail, but we're going to give you some chances to get out until your trial. We either let you go on your own recognizance, which basically means we're going to recognize that you're not a flight risk. You have enough connections to the area that you've been charged in that we know that you'll come back. We're not worried you're going to run away. Your charges aren't so serious. You're a threat to society, et cetera, that we're going to take it from your own word that you're going to come back and face your charges. But then you have that third category, which is, listen, we'll let you out, but you have to put up a certain amount of money. And can you talk, number one, about how that determination of an amount, how much does somebody actually have to pay? What are their options when they don't have that kind of money sitting around? Like, how does that work? That middle one where it's like, you got to put up some money to get out of jail.
Yeah. So there could be a situation where the judge sets bail at a straight cash amount, and you need to post that entire amount in order to be released. There could be situations where the judge puts a condition of 10% on that total bail, and the 10% of that total bail needs to be paid in order to be released. In situations where a client cannot afford to post the bail, 10% or no 10%, a client can go through it's called a bail bondsman. Bail bondsmans usually will require the client to post a small percentage of the total bail, 2, 3, 4, 5%, and the bail bondsman will post the rest. And the bail bondsman's banking on getting that back plus interest at the conclusion of the case. Now, in those types of situations where a client is going to go through a bail bondsman, the bail bondsman's going to look to the client's financial wherewithal, right? They're going to look to risk factors. Is the client going to skip bail? They're going to look at your financials, your income versus debt ratio, what collateral you might have. Do you own any property that we can, put a lien against? Because if a bail bondsman is going to post $100,000 bail, for example, he or she's going to want to ensure that they're going to get that money back. So they're going to look at the entire financial picture. They're going to look at the longitudinal view of a client's financial situation before making a decision on whether or not to post bail. That's how that works.
So if someone posts bail, whether it's out of their own pocket or they use a bail bondsman to do that, what happens if they don't show up for court?
Bail's forfeited.
Okay, so
Bail's
that
forfeited.
the court system now keeps that money regardless of where it was paid from, and I'm assuming they're now facing additional charges or whatever for not showing up for court.
In theory, yes, the bail's forfeited, but really what happens in practice is there's, let's say that the client misses their court appearance, the bail's forfeited. The court can reset bail, can reinstate bail. So let's say that it was $100,000, 10%, and the client skips bail and then's arrested and taken into custody. Bail can be reinstated at that $100,000, 10%, so that it's not forfeited. That's typically what we see in practice. But in theory, yeah, if a client skips out on bail, that bail's forfeited.
And if they got it through a bail bondsman, that's when the bounty hunter's coming after you. Is that's that situation?
SOL, we call the bail bondsman, and that's when they get a bounty hunter to track you down.
Right.
And that's why before a bail bondsman becomes engaged with you, they're going to look at your financial picture. The last thing a bail bondsman wants to do is try to, they're going to keep tabs on you. For example, some conditions might be if I'm going to post bail on your behalf and act as your surety, you're going to be required contractually to be checking in with me once per week. They're going to keep tabs on you because they don't want to have to go out there and track you down.
Right. They're not in the business of having people run out on the money they put up for them.
No, they are not. Not at all.
Gotcha. Another area we touched base in this, again, the prior episode, I just want to dive into a couple questions here. I think you had mentioned that plea deals, from your experience, are typically happen after the preliminary hearing and during the status hearings and conferences. That's typically where the parties are getting together and saying, "Look, is there any way we can work this out?" And that's where you're horse trading a lot more. You see it typically happening, but Is there any reason that in any stage of the process that a plea deal can or can't be worked out? And I know you talked in the other episode about at the preliminary hearing, for instance, maybe you agree, and it's a kind of a plea-ish deal where you're saying, hey, drop these certain charges and we'll agree to let the other two move forward. Are there any other areas or anything you've seen where plea deals are worked out earlier or later in the process? Can you just touch base on that quickly?
Sometimes I see on the 11th hour a plea deal reached, or we're scheduled to go to trial the next day, or sometimes I see during trial a plea deal is reached where, one side's not doing well during trial. The prosecution's not doing well. They know that they're losing at trial. The defense might, be offered a good deal, to try to get the case resolved. I've seen it where I had a jury trial in a sex offense case, 3 days. It was a hung jury. Jury could not reach a unanimous verdict. We were going to have to come back to retry the case the following month. We got a plea deal. So plea deals can be reached really at any stages. There's no such thing as it must be reached prior to the start of trial. It could happen whenever.
But I don't know. I think this is correct, but you think it doesn't make a whole lot of sense in most situations to start talking about a plea deal until at least you've had the preliminary hearing so you understand, A, whether the charges are moving forward at all, and you have an idea of what kind of evidence the other side has.
Yeah. Generally speaking, you don't want to reach a deal until you've seen the totality of the case, all the evidence. You don't want to reach a deal until you've gotten to that point, generally speaking.
Okay. And if someone agrees to a plea deal, do they have to show up for court after that? Are they going to be required to show up for court?
Yeah. So, there'll be a court proceeding called a guilty plea hearing, where, a document will be, you have to go through a document called a guilty plea colloquy, explains the rights you're giving up. A guilty plea is a really serious proceeding. You're giving up your right to a trial. You are admitting to facts. The guilty plea is a conviction that will stay on your record. And so before you plead guilty, the court needs to make sure that you're freely, voluntarily, knowingly, and intelligently making a decision on your own free will. Nobody's forcing you or threatening you to do so. Very important hearing. So it's not like you just decide to plead guilty and that's it. You got to go through a proceeding for that.
And I would assume you mentioned that there are plea deals where the sentencing is left open. So, in that case, especially, I would imagine the judge wants to know, hey, you still don't know what this is going to mean for you in terms of jail time. So you got to be aware of what's in front of you. Exactly.
Right. You got to go through the plea and then there's the sentencing phase. So there's still proceedings even after the parties reach a deal.
Okay. What is ARD?
Sure. So it is a first-time offenders program. It stands for Accelerated Rehabilitative Disposition, and it's a program designed for first-time non-violent offenders. And basically, what it does is it's a probationary period where after you've completed that probationary period, you can earn a dismissal of all charges and get the charges expunged from your record without having to admit to facts, without having to plead guilty. It's a wonderful program. It's designed for people who've made a mistake, a nonviolent infraction of the law, and it's a program to allow you to get the charges dismissed and expunged.
And I think most people have probably heard of ARDs in the context of a DUI, but can it apply to other type of charges as well?
It can. It's up to the sole discretion of the district attorney. It's not something that the judge could approve. The judge is not the decision maker on whether or not a client gets ARD. It's to the sole discretion of the district attorney. Now, the district attorney needs to be very careful because he or she has that's a lot of discretion to give to the district attorney whether or not somebody qualify for this wonderful program. So the district attorney will have guidelines as to whether or not somebody qualifies. For example, we know that if there's a DUI type situation with a child in the car, automatically that client's not getting ARD. We know that if it's a very, very violent offense where there's firearms involved and somebody was assaulted, that person's not getting ARD. So there's uniformity across the board with who qualifies. There are certain situations where a client could be denied ARD on initial application, but then we could appeal the denial and request that the district attorney reconsider the ARD application. That happens a lot. And on reconsideration, a client can be approved for ARD. So it varies from county to county, but generally speaking, across the board, the guidelines on whether somebody qualifies are pretty uniform.
Gotcha. And how does it impact someone's legal sort of chances or process when they've got a history of prior arrests and convictions? I think tying this back to ARD, that's out the door because you have to be a first-time offender. But in other kinds of charges, how hard does the DA's office, does the court look at prior convictions and things like that when deciding to, whether to plea, how the sentencing goes, all those types of things?
Well, ARD, I mean, by definition, it's for first-time offenders. So if you have a previous conviction, a previous offense, by definition, you're not going to qualify. But there's limited circumstances where a client's prior offense, the prior conviction, is so old and so far removed from the instant offense that an exception can be made. For example, I have a client who retained us that it was just charged with a DUI, but has a DUI from 30 years ago. Hopefully that client gets ARD. We're going to certainly make application. So there are exceptions that can be made even where it's not the client's very first offense.
Gotcha. But and even if they're not going after ARD, if you've got a history of convictions and things like that, and you're charged with something, does that typically come into play? People are going to look at their past history to determine all those things, sentencing, and how hard they're willing to negotiate.
Listen, if this is your 7th shoplifting offense, it's going to be. They're going to be looking. The judge, district attorney is going to be looking at, your 6 prior shoplifting offenses, and that's going to be used against you.
Okay. Now, this next couple questions I'll go around. You use the term expungement. So, number one, can you explain what that is, and then talk about how this relates to criminal records and how long they're online, or how long they're available, how long they stay online, and things like that?
Yeah. Common misconception we hear in this business is, I had something, but it was 10 years ago, it was expunged or it dropped off. That's not how it works. An expungement is an erasement. It erases the conviction from your criminal record. And there's limited circumstances where somebody would qualify for an expungement. One of those circumstances is if a client completes an ARD program. Charges are then dismissed and can be expunged. Another type situation is where a client is found not guilty of a crime and they go to trial and they're found not guilty. They would qualify for an erasement, for an expungement. Another type situation is if charges were dismissed, let's say at a preliminary hearing, it never even reached the trial stage. That's another type situation where client could qualify for an expungement.
So with expungement, I think you mentioned there are different situations where it could qualify. Maybe it's age. It could be that a dismissal. It could be that a not guilty verdict, ARD, different things like that. Is that automatic, or does someone have to go through the process to get the records expunged?
Yeah. So some counties will say once you've completed the ARD program, it's automatic, and I'm sure it is. Even in the counties that say that it's automatic, you want to go through the process. There's a petition that you file with the court to expunge the record. Once that petition is granted, an order is signed by a judge directing the agencies to destroy and expunge the record. That order then needs to be sent out to the agencies. We send it out by certified mail, along with an affidavit, which is a signed and sworn statement by the agency indicating that the order to expunge has been complied with. So there's a process to it to make sure that's done correctly. And that process can take upwards of 6 months. So even in the counties that say it's done automatically, you still want to manually go through that process to ensure that it gets done.
But absent an expungement, people's records are potentially available to be found forever.
Yeah, yes and no, not necessarily. We also have what's called the limited access laws. We call them seals if the record gets sealed. And that's a situation where a client does not necessarily qualify for a complete expungement, but under the limited access laws, they can get their record sealed, which means that the record's only available to government agencies, not employers, not banks, not loan officers, not landlords, only to like the state police, for example. And that's how the limited access laws work.
Does that apply, or is there a different set of rules for juveniles that would have been charged with a crime?
Juveniles are a completely different category altogether. The expungement laws for juveniles are very, very broad and very favorable for juveniles. We don't want to see a juvenile in the system for life. The purpose of juvenile court, which we can get into some more if you'd like, is to rehabilitate, to hold the juvenile accountable, but to rehabilitate so that he or she's never seen in the system again. And so in that respect, the juvenile expungement laws are very broad, and only in a very, very limited set of circumstances will a juvenile's record not be expunged. And those are generally sex offense type of cases where the juvenile would not be able to get the record expunged.
Well, we will go in juvenile offenses in more detail in a future episode, so we'll save it for that one. So we're coming to the end of episode 9 here, and I have a few more basic questions for you. So,
Sure.
Do you have a feel? And I think some of this is driven by how quickly things have to go by law, but also from your experience, how long does it take from arrest to preliminary hearing typically?
That's a good question. I get that a lot. It could take, I mean, the preliminary hearing dates always get changed around. They always get moved. It could be judges unavailable, the officer's unavailable, the lawyer's unavailable, the client's unavailable, an act of God occurs. So those dates always get pushed around. We usually see 30, 60, 90 days from the time of arrest that it occurs. It could be shorter, it could be longer. But that, generally speaking, that's what we see.
Okay, so
Yeah.
30 to 90 days is a good benchmark of when you would expect someone to have preliminary hearing.
Correct. Now,
Okay.
now, if at their bail hearing they're held in custody and they're not released, then the preliminary hearing has to go off within a certain time period,
Okay.
unless, of course, the client waives that time period. But that's a different circumstance altogether. Generally speaking, 30 to 90 days is what we see.
Gotcha. And then preliminary hearing to trial. I know you mentioned in the previous episode that can take months and months, but do you usually, when someone asks you about the timing on that, set expectations about how long someone should expect to wait between those two?
I usually say, I mean, it varies from county to county. Generally speaking, the time from preliminary hearing to trial, generally speaking, is anywhere from 4 to 6 months, 3 to 6 months. It could be shorter than that. It could be longer than that. But that's a general barometer, if you will.
And of the cases you handle, if you were to guesstimate how many actually go to trial, is it a high percentage, low percentage? What is it that actually ends up making it into the courtroom that way?
Generally, most of my cases go to trial because I'm getting higher end, more complex cases that we just don't get resolved. But it's all, so I guess it's all relative. But in general, a vast majority of cases resolved by way of a guilty plea type disposition. They get worked out. Vast majority of them. So most of my cases do go toward trial because I'm taking cases that really cannot be resolved. So,
Okay.
yeah.
And does it typically cost more money to go to trial than it does to resolve a case at a preliminary hearing? And, is that something that people should expect if they're pushing it all the way through?
Sure. I mean, trial legal fees depend on the scope of work that's involved, the amount of time that's involved, the ramifications that's involved. If we're going to trial, there's way more time that's involved in taking a case to trial than resolving a case through a guilty plea. So yeah, so yes, so trial fees are going to be higher than non-trial fees because there's more work involved.
And I think to your earlier point, it's typically a more complicated case, whether it's factually or background or witnesses or evidence or otherwise, that is making a case go to trial, which makes it a more difficult case than your average charges that might be filed.
Correct. That's correct.
All right, we're wrapping this up. One last sort of question for you. I think, well, number one, I think you said your advice is if and when you can do it, and you should hire an attorney as quickly as possible in the process, certainly before a preliminary hearing, but someone should invoke the right to have an attorney before answering any questions, agreeing to searches and things like that. Get involved to control that situation. So the earlier the better, I think, is your advice. Particularly, that you cut this thing off as early as possible. It tends to lead in better results. Would you agree with that statement?
Absolutely, for sure.
Okay.
I would
So,
agree with that.
So if someone is looking to hire a criminal defense attorney, what questions should they be asking them?
Well, you want to make sure that lawyer is experienced. You should be at how many years have you been doing this? What types of cases do you handle? Do you only handle DUI cases, or do you handle the type of case that I'm presenting you with? What type of firm do you have? Are you a solo practitioner, or do you have a staff? Because if you have a staff like we do, that's more power in the case. That's more bodies to the case that can assist. We'll be asking about trial fees and non-trial fees and how much things are going to cost. Is it a flat fee? Is it an hourly fee? Is it a retainer type fee? How is it going to work? Are we going to be speaking on a monthly basis, a weekly basis? Will we have in-office meetings? You want to make sure that you're comfortable with that lawyer, that you're going to work well with that lawyer, that lawyer is going to be communicative with you and responsive. You want to make sure that lawyer is familiar with the county in which you're charged in. That the lawyer has a familiarity with the players involved, the prosecutors and judges. So I think those are some general type questions that a client wants to ask a lawyer.
Yeah, and I think just to follow up on that, to wrap this up, is that hiring someone when you're faced with criminal charges is certainly an important decision, and not only do you need to know that you can mesh with that person, that you feel that they're going to represent you properly, but they have all the qualifications necessary to guide you through this process, whether it be from experience, whether it be from focus on practice areas, whether it be from familiarity of the courts and the opposing counsel that you're going to be dealing with. All those things come into play in making sure that you're properly defended, that you are given the right advice throughout the process. So I think that's all great questions to ask. Paul, I want to thank you for being here and answering all these important questions. That is the second part to our overview of the criminal process. We're going to be talking about the consequences of a plea or a conviction, plea deal or conviction. What's that mean? What are the things that go into that? And we'll be speaking soon.
All right. Thank you.